When you are being questioned at trial, and now you're being cross-examined by the opposing lawyer, does it matter whether he asks you a leading question as opposed to an open-ended question? You want to know the answer? Come join me on this walk through this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, it does make a difference. Now, you might be thinking, wait a second. I suffered injury because of someone else's carelessness. What difference does it make how the question is phrased in order for me to answer the question? I'll tell you as I manage and navigate my way over these big rocks here. And now, it does make a difference. Let me tell you how and why. All right, so let's say you sued your doctor claiming that he was careless, causing you significant harm and injury. And now you believe that your injuries are significant and permanent. You've had a medical expert, through your attorney, review all your records who confirms that you have a valid case. The defense disagrees with your assessment, they disagree with your expert, and now your case goes all the way to trial. Now you are at trial. You have just given lengthy testimony about what happened to you and what injuries you have as a result of the wrongdoing. It is now time for the defense attorney to get up and to question you, to try and pick apart your answers, to try and show that you are not credible. And now, the defense attorney gets up and he begins asking you questions. And from the moment he starts asking leading questions. And you're thinking to yourself, I don't care what kind of question he asks, my answers are going to be the same no matter what. If I need to explain, I'm going to explain. If I need to tell him something else, I'm going to tell him something else. Well, I'm sorry to tell you, but that's not how it works. If the defense attorney is going to be asking you leading questions, it means he wants a very specific answer. He wants you to answer either yes, no, I don't know, or I don't remember. That's it. If you now begin to add information to a simple question that calls for either yes or no, now you, the injured patient, now you are the one who is going to look like you're trying to add stuff, like you've got an agenda that you want to get out information in front of the attorney and in front of the jury and in front of the judge. So for example, if the attorney asks a simple question such as, hey, Mr. Jones, did you see my client for the first office visit on January 2nd? And now instead of answering a simple yes, I did, you now proceed to try and answer the question in a 2-minute explanation. And now, you think that's going to make a difference? The answer is, it will. Because if you continue to do that in response to every single simple question that the attorney asks you in a leading fashion, now you, the injured patient, are going to look as if you are intentionally trying to add material and information to your explanations. And that's not always a good thing, because you want to be perceived, you want to be seen as someone who is at least trying to comply. You, in all likelihood, are the underdog. The defense attorney is the evil guy, right? He's the evil guy trying to show that you are totally wrong. And now, if you continue to frustrate him and give him answers that he's not asking for, now you're going to run into a credibility problem. In addition, you are now going to wind up fighting with the attorney because the attorney's going to come back and say, excuse me, Mr. Jones, I asked you a simple question. Did you see my client January 2nd? It's either yes or no. Well, I know that on January 1st I made an appointment because I was having a problem and then I called this one. Just answer the question. It makes a difference as to whether it is a leading question or what we call a direct open-ended question. So let me give you an example of what a direct open-ended question would look like. Hey, Mr. Jones, tell us what happened when you got to Dr. Gonzalez's office and now you go in to see him for the very first time. Now that gives you an opportunity to actually go ahead and explain, to tell the jury exactly what occurred from the moment you walked into his office until the moment you walked out of the office. That's the difference. The difference is that now you are being asked to explain. Tell us, explain to us, show us. That gives you, the injured patient, the opportunity to go ahead and to fully explain exactly what occurred, what you remember happening. If, on the other hand, the defense attorney simply says, okay, isn't it true that when you went in to Dr. Gonzalez's office for the first visit, they made you fill out some paperwork? That calls for yes or no. Okay, after the paperwork, did a nurse come in to examine you? Yes or no. They don't want to know explanations. The attorney isn't asking for a detailed explanation, just simple yes or no answers. Okay, and after the nurse came in, a few minutes later the doctor came in, isn't that true? Yes. And the doctor introduced himself, isn't that true? Yes. And after the doctor introduced himself, he asked you a simple question. Why are you here? Do you recall that, Mr. Jones? Well, yes, I do. Okay, so now the attorney is trying to do what? He's trying to establish, number one, control over the questions, as well as control over your responses. Now, again, you might be thinking, wait a second, what do you mean he's trying to control my responses, my answers? One of the things every good attorney is going to try and do on cross-examination is not give you the opportunity to explain anything. Why? Because he wants to tell his side of the story through your answers. And the only way he can do that is by asking leading questions that call for you to respond either yes, no, I don't know, or I can't answer. That's critically important. So what's he going to do? He wants to establish that during the course of this visit, the doctor examined you and did a detailed history before ever putting his hands on you to examine you. That's what he wants to establish. Because one of your claims is that the doctor failed to do certain things, failed to obtain a proper history, failed to do a proper physical examination. So now he's going to lead you step by step throughout that office visit to establish his point of view. And the only way he can do that is by asking leading questions. If he were instead to rely on an open-ended question and say, hey, Mr. Jones, isn't it true that the doctor did a full, thorough history on you? And you're like, no. Okay, so where does that get anybody? The answer is it doesn't. Mr. Jones, isn't it true that the doctor did a full, thorough physical exam on you? No. He missed this, this, and this. And now, what has the attorney done? He's given up the opportunity to control the story. So getting back to the title of this video, does it make a difference how the attorney asks the question? The answer most definitely is yes, it does. A leading question will get you to answer only yes, no, I don't know, or I can't remember, rather than giving you the opportunity to go ahead and explain, say, hey, Mr. Jones, tell us what happened. And now you go on for 5 minutes at length detailing every single thing that you remember. However, that's not what he's asking. So why do I share this quick information here on this deserted island, here in the middle of the Caribbean? I share it with you because I have a few minutes. My wife is out picking seashells, and I wanted to share this great information with you to open your eyes and to explain to you exactly what really happens during the course of a trial in New York. You know, I realize you have questions or concerns about your own matter. Well, if your matter did happen in New York, not on the Caribbean island, not on this deserted island, but in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.